This is Professor Porter. This is criminal law. We're talking about the felony murder rule today and rounding out some of our teaching as it relates to homicide. So you can recall from common law, we didn't have degrees of murder. We just had unlawful killing of another human being with malice aforethought, a complicated intent definition that was rounded out over the years and of course includes intent to kill, intent to commit grievous bodily harm, where someone dies. We talked about in a different video, depraved heart and extreme indifference towards human life, essentially an applied malice theory. And then malice aforethought, that definition, that common law definition, also includes the felony murder rule. So we'll talk about it here. And felony murder rule has a few unique attributes having to do with its intent, having to do with its expanded timeline, and over time, at common law, some of the limitations that had to be imposed on the rule. So if we look at a statute, first, this happens to be the Colorado first degree statute, you can see, again, these are choices that the state legislature would make, anyone drafting a penal code can make, and you can see what they do here. They talk about first degree murder, anyone who attempts to commit, we'll talk about that in a second, but they pick their underlying felonies. They pick their felonies that if a death happens during robbery, burglary, kidnapping, etc., or any attempt to do so, it's going to be murder in the first degree. So not only do they embrace in their statute a felony murder doctrine, they actually elevate their felony murder doctrine to be a murder in the first degree. And there's a few jurisdictions that do that. And here you see some other language that's going to become important in a second when we talk about the expanded guidelines. It's only not only the attempts, not only the sort of preparation, not only the front end or the pregame, it's also if it occurs in furtherance of crime or immediate flight from the crime. So you can see Colorado here in its first degree statute embracing the felony murder rule. They also sort of speak to that expanded timeline. It includes intent, so the pregame, and it also includes things that happen in furtherance of that crime or immediate flight from that crime. So that's sort of a postgame. So more than just happening during the robbery or burglary, it can happen before the robbery or burglary. It can happen after and during the flight from a robbery or burglary at all. So here we talk a little bit about some of those theories, right? So we have attempts, and we're going to learn more when we talk about inchoate crimes. We're going to learn more about attempts, but just know that it means essentially the crime doesn't have to be committed. There could just be substantial steps taken in the direction of the crime, overt acts taken in direction of the crime with the requisite mens rea, specific intent to commit that crime. Again, could be in furtherance, could have in flight from, which we'll see from some of our cases. So we're actually taking intent and implying intent to include any type of death that results, even if the death happens to be an accident during that robbery or burglary or kidnapping or escape. Even if it's an accident, even if it wasn't the game plan going in, we're really kind of lending itself to a foreseeability test. The cases that we read are largely going to have to do with some limitations, and you're going to see when we look at the California statute, we need these limitations because murder two and some generic forms of felony murder are still sort of death that happened during any felony, not just the enumerated ones. The enumerated ones might have an elevated place in the statute like murder one, but felony murder is still embraced as part of malice aforethought in a lot of definitions and a lot of statutes. So therefore it needs these limitations that we'll talk about. Inherently dangerous felony, that is, what is the felony where death happened? Is it at least a felony, not tax evasion, is at least a felony where, like burglary, like kidnapping, like robbery, where it's foreseeable, it's dangerous, it's inherently dangerous activity. We'll talk about the murder doctrine or an independent felony. You know, sometimes if someone is engaged in an aggravated assault or some kind of battery, where they're striking another person, hitting another person, bringing force to another person, and then death results. You know, it's really the underlying felony is sort of the same thing that brings about and it's sort of a bootstrapping effect that we would get to murder. So we want it to be sufficiently independent. Burglary, intent-wise and otherwise, is sufficiently independent than the death that results. And lastly, agency theory. You'll see from some of the fact patterns, at least at common law, that every once in a while we'd have a security guard that would be engaged during the robbery. There would be a gunfight, and the security guard would shoot someone, including a co-defendant, And our defendant would be held liable for that because it was foreseeable. If you're bringing guns to a robbery, it's foreseeable. So the agency theory is the defendant, or at least some agent, someone in an agency relationship with that defendant, has to be the one that actually pulls the trigger and commits the act. So there's some certain limitations to counterbalance some of sort of the expansive criminal liability that flows from the murder doctrine, felony murder doctrine. It's one of the reasons why it's so controversial. Here's a graphic that hopefully, spells it out a little bit. We have a felony that happens, but we also have this idea that, that there's some attempt in the front end, there's substantial steps taken before you get to the felony. So we're looking at the attempt side of it, and can we hold someone, essentially attempting to commit a robbery, even if they actually don't even get to the robbery, which you don't have to commit the offense for an inchoate offense like attempted robbery, attempted burglary. And the flip side of that, and the defense argument for that, is these steps are mere preparation. It can't be, it's not a substantial step in the direction of the crime if it's just mere preparation. So a defense attorney might be arguing, hey, these steps that were taken, these facts that are pointed to, this evidence that's elicited at trial, this really goes to mere preparation on behalf of the defendant, not substantial steps taken in the direction of committing that offense. Therefore, my guy did not commit the underlying felony, so any death that results, he didn't commit the felony murder. You can see why it becomes so important as to that fine line between mere preparation and attempt. And in the back end, when we're talking about something in furtherance of or flight from a felony, you see deaths that result. The robbery's over. They're in their getaway car. They're leaving. And then a death results down the road. There's a fine line between sort of that fleeing, that in furtherance of, and getting all the way to a place of safety. So the defense argument may be, no, they made it to a house. They were on their way. We're now, sort of the next chapter in the play. We're at the next place. And it was a place of safety. The evolution of the felony, including furtherance thereof, including flight, is over. If a death resulted from that point forward, you have to evaluate that death on its own, not in conjunction with the underlying felony, underlying conduct. So that fine line between in furtherance and place of safety is another place ripe for a prosecution argument in furtherance or in flight from, versus a defense argument reached a place of safety. So looking at this graphic, you see the felony, and during the course of the felony, is only a subset of the liability, hence why we need some of the limitations. Here you see the California murder statute, and again, like Colorado, like we talked earlier about in the video, they not only have some of the familiar patterns of murder one statutes with the willful, deliberate, and premeditated, they also pick ways, a manner of killing, like poison, lying in wait. But you can see they too, California too, its legislature in crafting its penal code, says murder one is in the perpetration or attempt to perpetrate. There you see the attempt language again, and they pick theirs: arson, rape, carjacking, robbery, burglary. Those are the ones that are going to be those underlying felonies if a death results during it, including the attempt, so the fine line between mere preparation and attempt, and including in furtherance of thereafter, because that comes from the common law. So you see they're incorporating it in their murder one statutes. And the last line here, all other kinds of murders are second degree. Well, what is second degree in California still incorporate? Here you see it. Second degree has intent to kill, has depraved heart, so it has and it also has unenumerated felonies. So that means second degree murder as it stands, section 189, includes felony murder that is death that results from any felony, even one of the ones that's not listed in its first degree statute, which makes it more like pure common law murder, when that malice aforethought definition that includes the intent to kill, intent to commit grievous bodily harm, depraved heart, and felony murder in a common law sense. So most of the cases that we read, they happen to derive from California because they're interpreting it like common law. We have to impose this limitation for inherently dangerous. We have to say that this underlying battery merges or is not sufficiently independent from the crime when it brings about the death of someone else, or we have to go for that agency theory as to who's actually doing the shooting that brings about the death, who's actually engaged in the act that brings about the death. Are they the defendant or an agent of the defendant?